Actually, I don't know the difference between a secretary and a paralegal and an attorney. We all three of us do the same things, really, when you think about it. In fact, tonight's material is on contracts, and more so in contracts is the area that we all three of us do things in that. I mean, if you're an attorney and you're typing up your own letters, you're a secretary, you're drafting the letter or the agreement, or you're a paralegal and your specialty's document preparation. We all see lots of contracts come across our desk. We see employment agreements, we see promissory notes, mortgages, real estate purchase contracts. I mean, there's a plethora of contracts out there in the world. Probably, I think, the most important area of law. I know that Evelyn was saying that you have bankruptcy coming up and you have probate and whatever else. All of that, all of those other areas of law have a substantial portion or content of contract law. You cannot do anything under the law, I don't even care the criminal law area even, tort law even, that doesn't involve contract. If you're going to do a settlement of a tort law type case and you're going to settle a litigation case, that's a contract. Criminal law, a lot of times with criminal law we see nowadays comes out of contract. People doing identity theft, people doing agreements that are illegal, that type of stuff, again, all out of contract. Every day we all enter into contracts without sometimes unwittingly even knowing it. You go and you buy a lunch at a lunch place down here downtown, you go to a soda machine and you put your coins in and you get a soda out. Things that we do inadvertently during the day without even thinking about it, contract based. You pay your electric bill, contract. You pay your rent, for your lease, contract. You pay your mortgage, contract. Contract is just all around us. In fact, some of us don't even know sometimes when we're entering into a contract. It's so easy to enter into a contract, and without really knowing what a contract is, we don't know at what point in time is it that a contract actually comes into place. And contracts are very important. If you want to change law or create new law, you go down to the state legislature, you put a bill in, you go get it through the House, it goes to the Senate, goes to joint conference, it signs off by the governor, and you have a new law that now creates rights and obligations. By statute, it takes a long time, it may never go through. Literally, contract is that private law that we create. Private law means you and I enter into some discussion. I want to buy your car for $5,000, and you say, well, that seems kind of high, how about $4,500? And I say, okay, I accept. I mean, boom, at that point in time, a contract is formed that creates enforceable rights and obligations. You don't need to go to the legislature, you don't need to go to court, you don't need to do anything. We have rights and obligations that we created at that instant in time, merely by having three components present. We need three things to have a contract. We need three things that need to be there. If those three things are there, then if we have a contract and those rights and obligations are enforced and one person doesn't do what they promised to do or to forbear from doing, means that you're promising not to do something or to deliver something, if that person doesn't do it, we have the right to go to resort to court and force that person either to do it or to sue them for damages for not doing it or get some kind of remedy against them. And you think about that, it's incredible. To me, it's magical. I mean, three things happen, and if somebody then doesn't do it, I can go to court, sue them, and make them do it. That's empowering. And if you want to look at Bill Gates and Warren Buffett and these people that, these fabulously wealthy people, I mean, where they get their wealth from is through contract. Bill Gates, it's through licensing of Microsoft, through Warren Buffett, it's from buying shares of stock and acquiring companies through contract in which he has controlling ownership. I mean, it's amazing what you can do with contract. You want to buy the house that you want someday and you're going to be entering into a contract. You need to know a little bit about contract for your own personal lives. It's very empowering. In the past, women haven't always been all that involved or interested in contracting, entering into them, whatever. Men, they're in the business world, historically, traditionally been doing that, and then men have gotten the benefits of it. Because if you're out there and you're entering into contracts to buy a business, to sell something, buy something, that's how you make wealth creation. Going out and negotiating a good job for yourself and negotiating terms of that employment contract so that you get what you're entitled to. And then if somebody doesn't do it, you have the right to force them to do it. Contract. Three things you need to have present to have contract. Very simple. An offer, which means somebody has to offer you something. You need to offer, I offer to buy your car, or you offer to sell the car. It doesn't matter what side of the transaction it starts on. An offer to buy, or an offer to sell, or an offer to perform services, an offer to receive services, an offer to deliver goods, an offer to take those goods, an offer to indemnify, an agreement to receive indemnity. It starts at the offer stage. Then you need an acceptance. Somebody has to accept it. I agree, I accept it. Okay, now that's pretty cool. You can say, I love you, and you say, well, I love you too. We got an offer, we got acceptance, we got love, okay? But that doesn't get you the contract. You need one more thing. You need one more thing, you need consideration. Consideration is not what we think of it as a normal word. Consideration normally means something of, we know sometimes it's something of value. It can be property. It can be an agreement to do something, to forbear from doing something. That can be consideration. It has to be something that's negotiated and bargained for exchange. Something has to be there. It can't be just, oh, I'll do it if I feel like it, or I'll give you my car if you want it. In those cases, there's no consideration involved. You need to be offering and accepting in return for something that is either a value, of property, of forbearance, which means I offer you $100 if you stop smoking, and you say I accept. If you actually forbear from smoking for the period of time we agreed, that's deemed to be consideration. Those three things are present, we have contract. The minute you have contract, rights and obligations attach. And that's very important again, because sometimes in our legal work that we do, lawyers will send off a letter from off their desk, or a secretary will draft the letter and send it off, or a paralegal will send the letter off. And the other side will send back a letter saying, we accept. And you go, oh my goodness, what are they accepting? We got to go back and look at what it was that, what it is that they're accepting. You go back and look at your original agreement, and in your original agreement you said, I represent this plaintiff who was injured in an automobile accident, and they're seriously injured. We want $200,000 for their injuries. And you get a letter back that says, we accept. And you go, oh my goodness, what are they accepting? They're saying, well, we'll pay you the $200,000 because it's worth $1 million. And now you go, well, wait a minute, I didn't mean to make a contractual offer. I was just negotiating. I was just proposing a number. I didn't mean to be bound by it. Well, the other side, they say $200,000, and they were thinking that it's going to cost them $1 million, and they send a letter back saying, I accept. The hair goes up on your arms a little bit, because now you're worried, my goodness, they're saying we have a contract. We have to settle. We have to settle. That's what the other side is saying. Now you write a letter back saying, oh, I didn't mean to make a contractual offer. I was just merely trying to negotiate. But see, that's where you get yourself in trouble. If it's not clear that you were just negotiating, but the other side sees that there's an offer was being made, and a reasonable person seeing that letter would believe that an offer was being made, and that's the test. Would a reasonable person receiving that letter and reading it think that an offer was made? If the answer to that is yes, and the other side sends back a letter saying, we accept, you have offer, you have acceptance, you have consideration, and now you have a contract. Well, Hawaii also has a disciplinary rule which says that before a party can accept a settlement on behalf of their client, they're supposed to get written authorization, or some form of authorization from their client before they accept. So now you've got an attorney who wrote off a letter proposing a settlement, the other side says they accept, and you didn't want to make it a contractual offer, you want to just negotiate. Now you've got a contract that's arguably binding on your client, and now you want to get out of it, and you never got the letter from your client for that authorization. What does that mean for you folks? Well, I mean, if you're a paralegal or a secretary or working in an office in some form in which you're assisting an attorney, and that letter goes out, and I did one myself today. I've got a client I'm representing who's owed money on a promissory note, and the other side wants to negotiate an extension of the note and additional terms for payment. And I sent out a letter saying, my client's agreeable to giving you a 1-year extension at a higher interest rate with half payment now and the rest paid $3,000 a month for the next 12 months. And at the bottom of my letter I said, this is not a contractual offer. This is merely an effort to negotiate a settlement. Any agreement must be placed in writing and signed by my client because I do not have settlement authority. And I put that in my letter to make clear that the other side's not going to send me a letter back that says we accept. Because I don't want to see that letter, because my client has not given me settlement authority. I don't want somebody coming back and saying, now we've got a contract and you're bound to it. So in the work that you do, I mean, some of the things you have to do when we talk about offer, acceptance, consideration is trying to be careful that you do certain things to make sure that you don't enter into a contract inadvertently before it's time. Now, when we get into contract, there's two bodies of law traditionally that cover contract. One is common law. That's the court-made law. We have 50 states, 49 of them are common law states. Louisiana is a French code state. But in all those states, courts make rulings on issues of contract, and that becomes what we call the common law of contract. We got a lot of it from England and Europe when we became a nation. We borrowed it from the English court system, and that carried over across the Atlantic and became part of our common law. And now we have our own American common law, where our own American courts have now created common law of contract. The other area of law that we have is referred to as codified law. It's Uniform Commercial Code Article 2, UCC. In Hawaii, we have UCC Article 1, Article 2, Article 3, Article 4, 9. I don't know how many articles there are now, but there's a number of articles. Article 2, UCC, Uniform Commercial Code, is the codified section for contract law. And both bodies of law exist at the same time. Meaning the common law is where it is, and it deals with certain issues, and the UCC Article 2 is a codified set of statutory law passed by the state legislature, and that law is in effect too. Now you have two bodies of law, but one does not negate the other. One applies to one type of transaction, and all of the rest apply to the other. Article 2 UCC deals with only the sale of goods. Goods. What does that mean? That means tangible personal property. Tangible personal property would be this desk, the microphone, a TV, something that you can hold, touch, feel, that has substance, you know, some kind of physical content. If the subject matter of a contract involves some good, a car, an airplane, a boat, a good, Article 2 UCC is the body of law you go to first to see if it applies. You go there and see if there's a code section that deals with that particular subject matter. If I'm going to sell you my car, and I'm going to sell you my car for $1,000, and I offer it to you, I offer to sell you my car for $1,000, and you say I accept, and the next day I get an offer for my car for $1,500. You call me back and say, Mr. Lenhart, I'm ready to come over and pick up the car. I got a check for $1,000 from you, and I tell you, oh, I'm sorry, I sold it to somebody else. And you're going to say, wait a minute, we had an offer, and we had acceptance, and we had consideration. We had a contract. We had an oral contract. And I'm going to go, am I going to deny it? No, I'm an honest person. I'm going to say, yes, we do. And they're going to say, well, then you have to sell it to me. You're going to tell me I have to sell it to you. I'm going to tell you, no, I got a better offer for somebody else for $1,500. I'm going to sell it to them because I'm going to make $500 more dollars. You rush to a lawyer. Maybe your boss works in your office or something. And you ask them, boss, Mr. Lenhart won't sell me the car. He offered to sell it to me for $1,000. I accepted, and I was going to go over to his office and pay him $1,000, and he won't take it. He's going to sell it to somebody else for $1,500. Doesn't he have to sell it to me? Doesn't he have to sell it to me? You're trying to find out what your rights and obligations are, particularly your rights. You want to know, does Mr. Lenhart have to sell it to me? Your boss is going to say, aha, or you're going to tell him actually. You're going to say, I attended this class. Mr. Lenhart says the subject matter of this contract is what? What's the subject matter of this contract? It's a car, which is what type of property? Tangible personal property. It's a good. What body of law are we going to go to look to answer this question? We go to UCC Article 2, and guess what UCC Article 2 says? Contracts for $500 or more, consideration of $500 or more, must be in writing signed by the party to be charged. Do we have a writing?
No.
Do we have anything signed? Who's the party to be charged? I'm the party to be charged. You're trying to tell me I must do something. You need something in writing signed by me promising to sell that car to you for $1,000 in order to enforce the contract. Did we have a contract? Did we have an offer? Yes. Did we have acceptance?
Yes.
Did we have consideration?
Yes.
We had all three things. One thing is missing. We have a contract. The question then is the contract enforceable? That's a different question. We do have a contract. It's not enforceable because Article 2 UCC says for a contract to be enforceable, it must be in writing signed by the party to be charged. No writing, no signature. I'm the party to be charged. My signature doesn't show up anywhere. It's an unenforceable contract. Okay? Just giving you an example of how you analyze. Under common law, I agree to come and paint your house